Good afternoon, everyone. Thank you for joining in for another session where I discuss another issue within the field of intellectual property rights. The focus of today will be on geographical indications from the farm to the fork. There's so many different issues involved in geographical indications as it pertains to foods, wine and spirits, and even non-agricultural products as well. But because we only have an hour, I'll focus my discussion today on certain issues that play out in the field of food and agricultural products in regards to the discussion for today. Okay, so before I go in depth with the geographical indication talk, and because it's a long-term to use geographical indication, so for short I often say GI or GIs. It is worth, in terms of its relationship with food and intellectual property. A recent study came out earlier this year in February. It was done by the European Union, and it has stated that food and wine and spirit geographical indications are worth over 77.1 billion euro in currency. And a lot of that, 57% of that is devoted to wine and spirits, but then food GIs and agricultural GIs account for 37% of that figure. So that's a whole lot. Most of the geographical indications that exist are in Europe, a lot of them in France, Italy, a lot in Switzerland. But as I will discuss throughout my talk today, we're seeing a change in that, in where countries from the emerging economies and even developed countries such as US and Canada are getting more, not US, I should say, but Canada and and also developing countries are getting on board and involved in registering products as geographical indications. And throughout my talk today, just bear in mind that consumers, including myself, a lot of us are interested in finding out where our food is from, how it's grown, whether there are any fair trade elements that comes to play in the production of the food item, and geographical indications it speaks to these dynamics as well. So let's start off by talking about it's positioned as a hypothetical case study, but this happens all the time. So on your screen, I've mentioned two persons, Tanya and Andrew, and they want to manufacture, sell, and distribute cheese locally. So think of this in Bermuda and to other countries as well, specifically the EU, UK, Canada, and the US. And they want to call the cheese feta style and Danablu style to appeal to the taste buds of consumers who have a fondness for these particular types of cheese. And then the question is, what geographical indication or GI law should they be thinking about in relation to these countries? And of course, the conversation here is more thinking of, okay, you'd like to call your product feta style or Danablu style, and you'd like to export your cheese to Canada or the European Union, can you use those names? So bear that in mind throughout my talk today. The other case scenario brings to fore coffee and chocolate in the context of branding your community or branding your economy. And so this particular case study is more focused on sustainable development issues and also more macro level issues surrounding development of the economy, which geographical indications has a contributory part to play or can play as well. In this specific case study, I've stated that a certain country is known for the distinct and premium quality of its cocoa and coffee yields. Its cocoa and coffee farmers want to know whether GIs is useful to brand their products. So this would be their coffee and their cocoa, and what types of sustainable development impacts are possible. And in regards to this specific example, I'll talk about it later towards the very ending of the discussion. So for the next few minutes, I'll talk about what a geographical indication is, what it means, the right it gives to right holders, and things to consider in naming your food, your wine, and your spirit products. And this is relevant not only, if you're interested in using the geographical indication registration system, which is not in Bermuda at the moment, I should say, but if a product is not registered as a geographical indication, or if there is no law supporting that interest, it can be registered as a trademark. And so the third focus point really goes to say, if you're interested, look at the issues that comes about if you register or if you'd like to name or label a product with a name or a logo that's already similar or the same as an existing geographical indication, whether that be in regionally or internationally, things to consider. And then the last point goes to that sustainable development dynamics that I spoke about earlier in terms of whether or not geographical indications, the food, the agri-product, but even the wine and the spirits, which I don't focus on much today, and I'll tell you why later, can actually enable sustainable development. There's a lot of talk about it in relation to rural development and so on. And I've written a lot about this. Feel free to ask me any questions throughout the talk for today. Now, when we talk about GIs, what are we really talking about? These are really words or symbols, and they're found on the packaging of products. And these words or symbol convey that there's a direct and traceable relationship between the product and where it comes from. Now, this relationship can either be by the quality of the product, its characteristics, or its reputation. So either the quality, characteristics, or reputation of the product must link to something that is essentially attributable to where it's from. Now, I've given a few examples towards the ending of the screen. So it doesn't have to be an agricultural product that is cultivated and harvested. It can also be something that is manufactured, that is processed. And in this regard, I've made mention here of the Cornish pasty from UK, so it's a pastry. There's also feta cheese from Greece. From Japan, there is the Kobe beef that comes from a particular type of cow species in terms of how it's grown. There's also the Colombian coffee. We're probably familiar with the Colombian coffee grown in Colombia. And all of these different examples, there is one important commonality in all of them, in that there's always something related to how it is grown. It could be the soil type, the climatic conditions, it could be the traditions or the culture or just way of processing the food item or harvesting the item that is so different and unique that it brings about a different or unique taste in the product. Now, the linkage with intellectual property is that because it differentiates the product in such a unique way, it is worth protecting. And there are differences between geographical indications and trademarks, and this I will discuss later in the talk. So based on what I've just said, you can see then the importance between where the product is grown or manufactured, how it is grown or manufactured, and sometimes by whom. Now, the third element here in terms of by whom, it could be the specific peoples that are producing the item in terms of they're using a particular type of tradition to produce the product. And as much as, you know, I'm talking about food and agricultural geographical indications, the element of by whom, you'll find it more in non-agricultural products, such as artisanal items. This could be handicrafts. When we talk about handicrafts, if you think of there's a specific scarf from India, Pashmani scarf, that is an artisanal item that is protected as a geographical indication. It could also be perfumes. It could also be pharmaceutical items. So the more you think of culture and traditions, you'll find that the connection tends to be with the people, and a lot of times it's not with the food. But what I'm trying to say is non-food items can be registered as geographical indications internationally. I'm aware that this is not yet available in Bermuda. Important then in bringing all of this together is the product and the place. And on your screen, you'll see 3 different logos. Remember when I just started talking and I mentioned that it's a sign or a symbol used to convey that there's a direct and traceable relationship between the product and where it's from. Now, you may have seen some of these logos before, or maybe even one. These logos are not specific to the product itself, but what happens is it's a logo that identifies that there is that relationship and that the product is protected by geographical indication. So what you'll find happening is that in addition, so right now I'm pointing at the middle logo, which is used in the European Union to connote that there is that the product that this logo attaches to is protected as a geographical indication. In addition to this logo, you will find the actual label by the specific producer about what the product is, right? And so here, this one is for the EU, and then the one to the left of my screen, this one is for India. In India, they started their registration system and registering products as geographical indications, foods, wines, spirits, and also non-food items from the early 2000s. The last one here is the logo that represents Jamaican geographical indications, which is fairly new. This is probably a year or 2 years, the most 2 years old. And what it signifies is that if there is a product that uses this specific logo, it means that the product is protected as a geographical indication. And I believe there are 2 geographical indication food items in Jamaica. One relates to Jamaican jerk and it's rum. In the European Union, it's thousands, and most of these are wine and spirits, but then a growing number of them are also food items. So it could be chocolates, it could be fruits, as a lot of them are fruits, hams, and other types of food products as well. In India, this keeps growing, and one of them, for example, just to mention, would be basmati rice. Now, in terms of what I've said so far, you'll find that to be a food or agricultural product geographical indication, there are three qualities that are necessary. One is the product needs to be distinct. So that distinct feature then is in the taste of the product. Usually it's in the taste. Appearance sometimes may be there, but a lot of times it is in the taste of the product or the quality, culture, and traditions. So the product needs to be distinct. If it is not distinctive in terms of these specific characteristics or reputation or quality, then more than likely it's not a geographical indication. It wouldn't get that registration as a geographical indication. Now, another element or dynamic or eligibility criteria for geographical indications for foods and even for wines and spirits is that it's a collective right. So unlike a trademark, where a trademark can be registered and owned by an individual, meaning one person or a firm, geographical indications can only be owned by a group of individuals. So in this regard, it could be a group of firms, a group of farmers, more than likely, a lot of times across countries, it's a group of farmers, or it can be also be owned and managed by a government body. And when I talk about government body, it could be, for example, the ministry in charge of agriculture or fisheries or seafood. They own the geographical indication, that specific product designation, and administer it. Although they may use or collaborate with private individuals to commercialize the product. So it has to be distinct. It's a collective right. And then the other point as well is what it gives you as the owner of that geographical indication is monopoly or near monopoly in the use of the name. And we'll talk about this further. So it's similar to trademarks, but yet it's a little bit different, because where it is granted, it's almost as if you have a perpetual or indefinite right to use the name. And we will see this later on in our discussion. Again, this is qualified by jurisdiction. It's really based on the jurisdiction that you're operating in. So what rights are conferred by these types of by food and agricultural geographical indications? So it varies across countries, although there is that trend towards moving towards a harmonization of rights across countries. There are still differences, and these differences are important to know, because it impacts whether or not you'll be able to sustain your product as a rights holder in your foreign market. And when I talk about the harmonization of rights, the backdrop to geographical indications, I'm trying not to be legal in this discussion, and I want to make this discussion very layman as much as possible, using terms that are understandable by everyone, and also from a business perspective. So out of the three webinars that this is the third one that I've been doing to date, I want to ensure, because this is a very complex topic, that everyone understands it. So I won't talk about much legislation in terms of going in depth in terms of what they're saying and provisions or so on. But just to note that the foundation of the recognition of geographical indications within countries globally comes from the TRIPS agreement. And TRIPS is an acronym. It really means the agreement for the agreement on the trade-related aspects of intellectual property rights. It's under the WTO, World Trade Organization administration, also administered to some level by the World Intellectual Property Organization. But essentially, all countries that are WTO members have to commit to minimum standards of protection for geographical indications. Minimum meaning they're not great rights or expansive rights, but just, some type of protection for geographical indications, for food geographical indications. And through this international agreement, what is laid down is that, and I'll talk about it when I discuss certification marks and collective marks and trademarks, but what happens is that each country have to protect food and agri products to a certain extent. But if it were a wine, think of champagne, think of Chambliss and other wines as well, newer ones like Niagara wine or that from Quebec or so on. Wine and spirits are given greater protection under this agreement here, under the TRIPS agreement. And so you'll find that compared to a food-based GI that is given a little protection, and I'll talk about it later, what these rights are, wine and spirits are given greater rights. And so I won't get into that discussion today, but feel free to, we can probably have another webinar, or I'll talk about it more at some other point in time. So the scope of rights then, is determined by how each country sees or lays down provisions on these rights. And across jurisdictions, I've researched and studied and written on this extensively for many years. You will find that there are differences. So jurisdictions may take either of these approaches. Sometimes they will use a standalone law to recognize food-based and agricultural-based, or even any types of geographical indications. And these are called sui generis systems. Examples of countries that use this type of standalone law to recognize geographical indications include the European Union, China, Japan, and India. And these are just a few examples. There are many more. And what the standalone law does, think of your Trademark Act, think of your Patent Act. So it's the same thing. You would have an entire statute that's devoted to geographical indications. And if you were to do a bit of reading on, on this in the EU, you'll find that in the EU there is an EC regulation on this, and then each country uses that regulation to implement their own domestic laws on geographical indication. So the first one, the standalone one, is very broad. It gives the greatest protection. China has it, but you'll find that with China's geographical indication law, it's more devoted to the interest of stakeholders within the country, and not so much to outsiders who may want to register their product as a geographical indication within China. At the moment, it's not possible. It would have to be registered as a trademark. Japan also has one, and India. Now, so that's one example. It could also be used as in terms of the scope of rights, can also be determined by under a Trademark Act. And an example of a jurisdiction that has done this is Canada. So Canada has laws on geographical indications in terms of registration, registrability, infringement, scope of rights, and so on. But what happens is it's incorporated within its trademark law. And so if you were to check Canada's Trademark Act, you'd find it under, starting from the Section 11 of the Trademark Act, and it continues a little further. And other countries may choose not to even have an expansive perspective or provision or recognition of these rights at all. And so incorporated within existing frameworks, not adding anything new to it, but seeing geographical indications as a certification mark or a collective mark or a trademark. And so if you're not familiar with a certification mark is similar to, it's a type of trademark really, and what it seeks to do is it stresses the standard or that quality about a product. And so you'll find that with a certification mark, whilst, for example, you could have a business and register a mark as a certification mark, and this is hypothetical because I've looked at the Bermuda's Trademark Act and I don't see reference to certification mark in it. But say you were to have a business and register a product as a certification mark, you cannot commercialize the product, you cannot license the product. All you can do is, you cannot commercialize the product. All you can do is license the product for others to use, right? Uh, because they are types of trademarks, the duration of these rights are limited to the extent that it lasts for 10 years and then it has to be renewed. With geographical indications are indefinite rights. So you'll find that in most jurisdictions, you don't have to renew it. It's just a continual, perpetual right that you have over the name, over the use of the name in association to your food, agricultural product, to your wine, or your spirits, except other jurisdictions may see it as a time-limited right, such as in India, and require you to renew that geographical indication registration after a period of time. And so you'll find then that the intellectual property comes out because of the traditions, the practices, the peoples, the climatic conditions. If you think about coffee, Blue Mountain coffee being grown at specific altitudes, and so it has a specific taste, or Colombia coffee being grown in a specific area and developing that specific taste that cannot be replicated elsewhere or not easily replicated elsewhere. And so then that's how the IP comes about in it. Another thing to note, before I go on as well, is that these types of rights, in terms of what is required to obtain this registration, for example, if we think about a coffee being grown in a specific area, what happens with geographical indications is that the entire country cannot be the zone where the product is farmed or manufactured. So there is usually a restriction on an area. So sometimes a scientific study is done, or some type of cultural study, something is done to show which area is the most appropriate area within that country that has the specific soil type, climatic conditions that are appropriate to bring about that taste or that distinctive quality in the product to make it worthy of being a proprietary right. And so I won't get into this today. But what you'll find happening is sometimes people who are left out of that cultivation zone are not too pleased, because they may be interested in farming the product, but because they're not into that zone, they're unable to be considered as geographical indication owners. So let's move on a little bit, and I'll get into your questions in a little while, and I'm hoping that you do have questions. The types of rights varies based on the legislation that is used in the country, right? So it could be expansive or broad rights, or it could be limited and restricted. So the expansive rights, think about the European Union or Japan or India, expansive rights. And I would say the most expansive, based on the legislation that I've read, seems to be that which is in the EU. So the other end of the spectrum are as a producer, this is important because whilst within your own country, geographical indications are protected against infringement and so on. But in another country where you export to, it's not. And so the limited recognition may come about through where it's protected under trademark, under the Trademark Act, or if it's seen as a certification mark or a collective mark. Now let's get into the rights per se, which I've mentioned before. What are these rights? So let's look at the first box on my left. In countries that recognize these foods and agricultural products as being protectable geographical indications, and where it's important to them, GI names cannot be used by other competitors, and sometimes even when the products are not in the same product class. What do I mean by this? Okay, so even in Canada, what happens is if a product is a registered geographical indication, or think of the EU, and I'll tell you why I don't mention the US after. So if it is registered and protected as a geographical indication, a trademark or a trademark application cannot use that name to refer to its product. So that's where that exclusivity element comes in. So once the product is registered as a geographical indication, it prohibits, other competitors are prohibited from calling their products that name. So if you think about Colombian coffee, and I'll talk a little bit about feta cheese, because with feta cheese, there is a difference in terms of which countries can use that name and which countries can't on their products. The other point to note as well is that these names cannot become generic. And what I mean by generic is they can never be seen as words that are used in everyday language that everyone knows about. And for example, ketchup is a generic name that is used to refer to, a tomato-based sauce, so to speak. And so because it is a generic term, it would not be registrable as either a trademark. It would not be registrable as a geographical indication either. But with geographical indication names, although GIs can never register a generic name as a geographical indication, but once you get that registration, some jurisdictions, laws allow for there never to be a proceeding where the GIs can be canceled. And this is really interesting and great if you are a geographical indication producer in these countries, because it means that your right is safeguarded. Where does this exist? In the European Union. And another place that you may find this happening, I shouldn't say place, but there is also this international agreement called the Geneva Act on the Lisbon Agreement for the protection of geographical indications and appellations of origin. And that may seem like a really long word, but don't worry, I'll give you I'll send out a information sheet after. And any country that signs on to this international treaty would then recognize the fact or the law that GIs cannot become generic. And so far, I believe there are about close to 40 member countries that have signed on to this treaty. GIs cannot be canceled also in jurisdictions that recognize geographical, food-based and agricultural-based geographical indications on very expansive terms. The other point too, which is interesting, is that terms such as imitation of, style of, like or similar to, or even a translation of the term is prohibited by use, to be used by the competitor. So that's really commendable. And so what it does then, if you think about it, geographical indications, these where it is recognized expansively or extensively provides right holders with a expansive, a great number of rights, substantive rights for the protection and the safeguarding of their intellectual property interest. Now, the point is that the interesting thing to note is, although it may provide protection in their home country, it doesn't work. It will be of very little use to them if it's not recognized in export markets. So let's now look at countries where, the right for these products in terms of the recognition is not at the same level as these countries on the left of my screen. So in these countries, and again, remember I mentioned a few slides ago about the TRIPS agreement being the backdrop to the recognition of these rights in most countries around the world. So these countries now abide, and so they do comply with the minimum standards required by this international agreement, but the recognition is limited. So what happens is, if there is an infringement, or you believe that there is an infringement, but there are limited redress that you can get. You have to prove that the consumer is misled or confused by the geographical indication name and the competitor's name in the market. Another way in which the infringement works to the benefit of the GR rights holder is if the good is falsely labeled. So say, for example, the product is made in Bermuda, and someone from another country, think now of, say, Switzerland, starts making the product and has a false label on the product to say this particular item is made in Switzerland using the same name of the product. So they use the same name, different origin. Then, even though in that country, in our hypothetical country, even though the recognition is limited, it would still be seen as infringement, which is good. And then, another point as well worth mentioning is that the GR rights, in countries where the GR rights are similar to trademarks, then it's very limited protection that you'd end up getting. Deshaun, how am I doing with time?
You're good. We have about 18 minutes left, but we do have a question.
Okay, please go
Chris. Chris asked, do you have any experience with what criteria is used for sustainably grown produce?
Chris, thank you for your question. So sustainably grown produce. So Chris, are you referring to, for example, the standards that are used? That's a question for Chris.
I'll wait for him to type back in to see what he says.
Okay, so I'll go on until I get Chris's clarification.
Okay, that was quick. He said yes. What methods?
Okay, so usually it would be, the experience that I have I'm thinking more of the certification that is required, because when you mention the term sustainability, it could be sustainable. Sustainability is a very broad term, right? So there could be sustainability based on intellectual property strategy. There could be sustainability based on the procedures and the code of practice used to produce the product. And so if it's within that, and I'm thinking that's where you're getting in terms of what is used to sustain the product, there are three things that I've experienced and that I recommend. One, it's the mixture. It's not just geographical indication. So one, it could be trade secrets, and that would be protecting those secret elements that goes into the making of the product itself. Anything that you would not want your competitor to know, because if they know what those elements are, they can easily copy it, and then your product would no longer be distinct. And so having some agreement in place, like a non-disclosure agreement between you, the owner, and your employees or whomever you work with or do business with or partner with, that's essential. So that's one. The other is public-private partnership. And also that's the extent of that would depend on the particular product that you're talking about. So I would need a little bit more information from Chris on that. The other point as well, if it's a food, if it's an agricultural product, then you want to think about environmental safeguards and whether you have any climate mitigation or adaptation strategy in place to ensure that if there's a drought, if there's a storm, if there's a hurricane, you still want your product to be sustainable, but what strategy do you have to deal with those situations? And that's where also public-private partnership would be important as well. There are a lot of factors, but Chris, feel free to email me, send me an email after, and we could talk about it more. Any other questions?
That's it for now.
Okay, so I'll quickly, we're almost through. I know there's not a lot of time, but let's go back to the first case study that I spoke about of Tanya and Andrew, and them wanting to manufacture and sell a particular type of cheese and call it feta style cheese and Danablu style cheese. Now, because remember what the geographical indication right does, it gives the rights holder the exclusive right to use the name, right? And to prevent others from using the name, the translation of the name, or even if the competitor adds words such as style, imitation, off, or so on. However, not every jurisdiction complies with these laws. It may not be something which is on their books in their jurisdiction. For example, this is not the case in the US. The US sees geographical indications as certification marks or collective marks. So it's registered as a certification or a collective mark. And under that type of statute, there's nothing that says you can't use the expression style, like a feta style or Danablu style. So you'll find that if you're in the States or even within Bermuda, you may be seeing and buying and eating feta cheese that is not from Greece, but it's called feta styled or something of the sort. And there is no infringement there because the US does not have the same type of law as in the EU or Canada or in some other Caribbean countries. So Tanya and Andrew would not be able to call their cheese feta style in Canada because they would not be able to export it here with that name because of the restriction. Now, in Canada, Canadian producers can use the term feta style if they were producing the cheese up to 2013, because we've signed this free trade agreement with the EU that says that is possible. But if you're a startup and you're just starting to process the cheese, say this year or last year or any time after 2013, you would not be able to use that expression on your cheese. With Danablu style, not allowed at all. The term is protected in the EU as a type of cheese. Danablu is a type of cheese, and the exclusive right to use that name is held by the producer, and neither can a translation of the name be used or words such as imitation, of, or style. So you see, therefore, it's important to know your market, right? Because if you don't know your market, you could be labeling a product or referring to your product with a specific name, but at the same time, the name cannot be used to refer to the product in another country because of the geographical indications law existing there. Are there any other questions, Deshaun?
No, there are no questions, but Chris said, thank you, great answer, lots to think about.
Okay, Chris. Thanks, Chris, for your question. And thanks, Deshaun. Okay, so we've somewhat spoken about this before, but in terms of considerations in naming your food product, your wine, your spirit, choice of name is important. If the name is already taken elsewhere, then especially if you're export focused, if your focus is on export markets, then the recommendation would be choose another name, especially if you're exporting abroad. And as I said, earlier, it's not just the name itself, but it's also translation of the name. So think about the French version or the Greek version of the name or anything of the sort is important as well. And your markets matter, right? So while if you're exporting your food or agricultural product to the US, and the addition of terms such as an imitation of or similar to or style of is acceptable or may be acceptable in that jurisdiction, it may not be acceptable in Canada or in the EU or in the UK, which are moving to have their own geographical indication legislation as well. The other interesting thing that is worth noting in regards to feta cheese, and this is again because of different free trade agreements that the EU has with different countries around the world, you'll find that wherein in one country it may be possible, as I mentioned in Canada, to use the term feta style. In other countries, it's not possible. For example, in CARIFORUM countries, and these are specific countries within the Caribbean, it's not possible to use the name feta cheese on the word feta on any product at all. And that specific restriction is found in the free trade agreement between the European Union and CARIFORUM countries. If you'd like a copy of that, let me know, I can send it to you. And the same thing with Parma ham in Italy, Parma ham from Italy. It's the use of the name here in Canada that's restricted, and there's a lot of conflict over the right to use certain cheese names in other countries because of geographical indications restrictions. So that's one thing, and I know it may have been a lot to digest, but feel free to ask me any questions even after the session, or if you need any help where all of this is concerned. So whereas I focused on more firm level issues, business issues regarding you and your business, the other part of the discussion for the next 5 minutes, and I do want to leave a little time for questions, is focused on, is there any relationship really between GIs and sustainable development? And if so, what does that mean, right? And I've posted a little excerpt from a chapter that I wrote in a book that was published, 2 years ago, that talks about the developmental implications of geographical indications. And this really refers to the use, because when a geographical indication is registered, remember it could be a food, an agricultural product, it's a farming activity or processing activity related to these items. There's a lot of jobs, hopefully, that are generated within that community, and the possibility of a cross-sectoral spillover effect from the commercialization and actually just the commercialization and management of the geographical indication scheme. So because of this, that spillover effect, there are possibilities that it may actually influence tourism, right? And I'll tell you, there is so much about this that we don't have time to go into it, but it may influence tourism trends in terms of driving visitor to your country or to that region, where think about wine. and bringing, or coffee, or people coming to those areas to see how the cultivation is done, how the process is done, having tours along these different areas and so on. That's a possibility. There's also possibility of diversifying the product itself and bringing in elements such as biofuel from the waste product of the product itself. So there are many different intersections that can be explored constructively to bring about development in rural areas. How does this work really? It takes a lot of collaboration and partnerships. So along these lines then, whether or not it influences development depends on 4 factors that I've listed here. The first is the product needs to be right. If it's a product that has low profitability, generating little revenue, you're not likely to see any economic development from that. And so you'll find that successful case studies, in successful case studies, the food or the agri-product or the wine and the spirit is actually of a premium quality. Think of Kobe beef that I spoke about before. A lot of times it sells for like $500, for a little pound or so, a piece of this beef. Think of, it could be Colombian coffee or basmati rice. There has to be that premium price associated with it. It also takes interest from key stakeholders, because of farmers, producers, different agencies within the government, the Minister of Tourism, Innovation, if they're not interested in maintaining or helping out these different stakeholders in as being a part of strategy, it will not work. There also needs to be reciprocity between legal reciprocity between the home country and another country. So say, for example, if you are, if Bermuda were to start having a GI law, and you are a producer and your major market is in China and you're exporting your GI to China, you're not going to find that your product is protected as a geographical indication. It may be registrable as a trademark, but not as a GI. So then you'll find that those expansive rights that I spoke about earlier would not be there. The other point is have a strategy in place. As I was talking to Chris, and I'm so glad that you asked the question, Chris, about sustainability, because if it's a product that's grown in the soil or so on, you got to think about climate change strategy. Is there one out there? Is there one that you're using? Because that's a part of sustaining the product as well. So I'll recap a little bit in terms of, what do you get from this talk today? Be familiar with the practicalities of what GIs are and how, it's something to bear in mind when you're exporting your food product. Because even though the law is not there in Bermuda, the law may affect you if you're exporting your item to another country where the law is recognized. There are also differences between GIs and trademarks, both in the definition and the scope of protection offered. Another consideration as well is if you're thinking about sustainable development goals, innovation, economic empowerment, and so on, through geographical indications, bear in mind it needs collaboration. It needs a collaborative framework in order for it to work. And so I'll end there for today. Feel free to ask me any questions. Thank you. Deshaun, are there any questions?
No, there aren't any questions. Chris did ask for your email, so I sent that to him.
Okay, great. Thank you, Chris.
Yeah.
Thank you. Well, thank you. I'll wait a little bit, a few more seconds to see if any more questions come in.
Chris just said, thank you guys. I'm not sure if we might see any other questions. But
Okay,
I would just say if you guys do have any other questions, that the email is there for you guys to reach out.
great. Thank you, Deshaun. Thank you for listening and watching this session. I appreciate it on behalf of BEDC. Deshaun, thank you as well.
No problem. Have a good one.
And you too.